And the next case on the docket is Rosa Thompson and Larry Thompson versus Westgate Vacation Villas, LLC. Yeah, let's
Get situated.
have a seat. And it's 5 minutes, okay, for rebuttal? All right. And you may begin when you're ready.
May it please the court.
Yes, good morning.
My name's Thomas Hippelhauser. I'm here for the appellants, the Thompsons. Basically, the issue in this case is whether this court can rule as a matter of law that Mr. Alicia, an employee of Westgate, was not negligent when he moved a pressure washing hose when he knew Mrs. Thompson was walking over it. The argument that was raised
Why
in
is
the
this
motion...
not an open and obvious danger?
The open and obvious standard applies to premise liability cases. This isn't, we're not alleging that this is something that's was created by the property owner and left unattended like your classic premise case, the parking bumper cases or the pallet case that they cited. This is a situation where a worker is doing his job, and in the course and scope of his job, he performed his duties negligently. Very similar to if he would have been driving a car on behalf of his employer on their property and ran into my client as a pedestrian. We don't look at premise liability standards when we look at that set of facts. In this particular case, the facts are he knew my client was stepping over the hose. That's what the evidence says.
And your client knew he was pressure washing?
She testified she didn't know he was pressure washing actively. She said she only heard the pressure washer running, which is what she also said she heard when she walked into the building and safely stepped over the hose that wasn't moving. And at that point, there was testimony that the pressure washing employees were taking a break.
Was there any testimony that that was the only way that they could get into the building was to walk over that hose that someone was using to pressure wash?
There was some testimony that the Westgate gave that they could have walked around the area in exiting. Our argument on that issue was there was no signage indicating that she should walk that way.
But that's common sense, right? You can either, I mean, if there's evidence that there's another way around, but she chose to step over a hose, well, I guess there were two people that went in front of her, and was it her husband that turned around and said, watch the hose, and she's stepping over the hose and then trips. A hose that's right there that she can see, that she sees and hears pressure washing, and that there's an alternate route that she could have taken exiting that would not have taken her over the hose.
That would be true if she had, in fact, had tripped on the hose. Our allegation in our amended complaint is that the hose was moved and tripped her. So,
Was the hose being painfully familiar with pressure washing? That's what I did in between, law school and a job. But is it the hose from the water source to the pressure washing machine, or is it the hose from the pressure washing machine to where you're spraying it off of the building?
it's the hose from the machine to the sprayer.
Okay.
And that's why we think...
So that hose, and your clients had indicated in evidence on the record that they, operated pressure washing machines, had done it in the past, and they had one personally at home, correct?
Mr. Thompson said that, yes.
Okay, and she was familiar with it too?
She was familiar with it. She said she recognized the sound.
Okay. So familiar with the fact that you got to move the hose, and the hose could move, as you're moving and pressure washing whatever you're pressure washing, correct?
Correct.
Okay. And they also walked over the machine en route to the office. All three of them did that successfully going in, and it was just when they were coming out that she was the one who tripped and fell.
That's correct. And the testimony was that when they were walking in, nobody was actually using the sprayer and so the hose was static.
Okay, but the machine was energized, correct? There was power to the machine, and then there was also probably water in the hose.
That That point is disputed in the facts. Mrs. Thompson says she did not hear the machine when she walked in. There was some testimony from, I believe, her husband that he believes he heard the machine running.
And the employee, is it Alicia or Alicea, or how do you pronounce the employee?
I'm calling him Alicia.
Okay. Originally, in the original complaint, there wasn't a negligence claim against Alicia, correct?
That's correct.
And then when you admitted the complaint, you still didn't name Alicia in a separate count. It was negligence within the original complaint against Westgate. Is that right?
Yes, under a vicarious liability theory.
Okay. All right.
I allege that he was acting within the course and scope. And the distinction that we want to make here, and we attempted to make it at both the hearings in front of the trial judge, is that he was looking at us. You take the evidence that's most beneficial to my client, there's testimony that this particular employee was making eye contact with these people as they're walking through the area.
It's almost like you're trying to make an intentional claim, correct?
No, it's just plain careless, that he didn't care that she was walking in the area. Even though Westgate has a policy that says you see pedestrians in the area, you stop doing what you're doing when you're pressure washing, and we ask them why. Because people can get injured. Well, that's the policy of Westgate, and he's seeing them in the area, and he proceeds to continue to pressure wash, and including moving the hose, then he's acting in a negligent manner. That's our claim from the very beginning. If you look at their motion for summary judgment, they never addressed the issue. They solely addressed the premise liability issues of open and obvious and duty to warn. And that's an area of law that's split off from negligence. The standard negligence theory, this particular employee had an obligation to perform his maintenance duties in a reasonably safe manner, taking into account the possibility of injuring people by moving the hose. We alleged in our amended complaint that he breached that duty, and they never addressed it. And yet the trial court granted summary judgment without explanation on how we could possibly have summary judgment when they didn't address the central issue in our complaint. As for the issue of the warnings, if you look at the record, the issue with the cones was that they were put up there to block traffic. And what the cones actually said was wet floor. So anyone walking past that cone would reasonably assume that that's a caution. When you're entering the area, be careful, there's wet floor. There's nothing about those cones that said, pedestrians don't come this way. They didn't put up a barricade. They didn't put up a sign that says, walk this way, something very simple to tell somebody to avoid the area. And
Well,
after they had
There has to be a little
safely...
bit of common sense involved, that you don't walk over a hose that's when someone's pressure washing, and there are cones in the area. I mean, that generally tells people that work is going on. I'm having a real problem not getting beyond the open and obvious. I mean, if you've got an open and obvious condition there, and people working, and you've got somebody that steps over a hose that's in use. I mean, wet floor, I can understand that on a cone, but also when you see a hose, reasonable people would assume that there's water around a hose as well. I'm having a really difficult time getting beyond
And
the
that's
fact
the-
this was open and obvious and there was another way around it.
And that's the issue in the case that we are arguing. That's something the jury should decide. Because for this court to say that simply a hose...
There's no disputed facts in this case that would dispute this being an open and obvious danger. What is there in the record that would show it's, I mean, everybody saw the hose. I mean, I don't see that there's even a dispute there.
The dispute is she didn't trip over the static hose. The hazard that she was open and obvious that she could see was a hose. She had navigated it. She was navigating it again.
Right, but that it was a pressure washer, that someone was pressure washing. And, I mean, there is a reasonable inference that when someone is working with a pressure washer that the hose is going to move.
And the analogy I would use is we all have been in Lowe's or Home Depot when those mechanical stocking carts come and try to put a pallet up on the shelf.
Right.
What did they do to protect the customers from being run over? It is obvious that's dangerous. Nobody would dispute that. They put up gates. They have beepers. They have flashing lights. They tell the customer who might not be as careful as we would expect them to be, we are about to do something that's dangerous, because this open and obvious danger of being run over by this cart isn't enough in itself. But they don't put flashing lights and beepers on it when it's parked. That's the pallet case. You should see that. Don't run into it. You're an idiot. But when it's in action and when an employee is there engaging in his job and he has an opportunity to see the careless person, he has an obligation to use reasonable care, and Westgate has a policy that says they do that.
So the cone shouldn't have said wet floor, the cone should say pressure washing.
The cone should have said stay out of the area. They should have put up a ribbon that says don't cross this area. They should put a sign that says walk this way. There's a lot of things they could have done to keep her out of the area, especially since she walked through the area and they saw her do it. She goes inside, she's in there for 15 minutes, and they didn't do anything else. They didn't change anything. They didn't say, oh, by the way, don't come this way when you come out. They did nothing. And then she comes out, and the testimony is they see her again in the area. Did the employee do what his policy was? Stop. Tell her to leave the area, wait for her to leave the area? No, he just continued doing what he was doing, and in the course of it, he tripped her. It wasn't the hose that tripped her, it was the actions of the employee that tripped her.
You're not selling me, but you can continue.
Well, but he didn't continue to do what he was doing. I think your words were he made eye contact with her and then moved the hose. You said carelessly, but it sounds to me more like if you're changing what you're doing and you're looking at the person and moving the hose, certainly seems a little more sinister than just carelessly doing something.
We don't know what he saw, if he just saw her in the area or if he saw her as she was stepping. I don't know what he saw, but he should have seen that she was doing it. The testimony was he made eye contact with Mr. Thompson, and their own policy says, stop. Don't move the hose, don't continue pressure washing. Had he followed that policy and she then trips on that static hose, we wouldn't have a case. It would be open and obvious. She shouldn't have been there. But because while she was stepping over what she thought was the same hose that hadn't moved before, he moves it, it slides up her leg and makes her fall. Perhaps comparative fault, but that's a jury question. Like I started this argument, to rule that we don't get to the jury means you have to rule as a matter of law on de novo review that it is not negligent for him to pull that hose when he is seeing her trying to step over it. And there's no case law that says anything close to that. It, in fact, is a jury question. Was he acting reasonably? Then the jury gets to answer the question that Judge Berger's been asking, was it reasonable for her to be in the area? But to say we don't get to his conduct because she should never have been there, she was there before. And they saw her.
But your position is it wasn't just negligence, it was carelessness on the part of Alicia, correct?
Negligence, the standard. He had a duty to avoid
negligence, you said carelessness earlier.
He didn't use ordinary, usual care.
But it wasn't reckless.
No.
And it wasn't intentional.
That's correct. There's no evidence to that. And the key part here is there's no contradictory evidence to any of that. The two employees, when asked about this incident, said they don't remember the incident. They don't remember who was even using the hose. It was only by inference that we were able to figure out it was Mr. Alicia and not Mr. Rodriguez. None of them saw her fall. None of them saw the hose. And yet their testimony is that we have a hose sitting on the ground that's static that you tripped on. And there's no evidence of that. The only evidence is from the two of the three people in our party that the hose was moving and it slid up her leg. And yet again, the trial court said that was an open and obvious hazard. There was never a situation when that hose was moving prior to the time that she was stepping over it.
How close was Miss Alicia to the plaintiff when the plaintiff fell?
He said, I believe, 10 to 15 feet.
So 15 feet away with their hand on the hose.
Yes.
Causing the hose to move the hose with sufficient force to cause the hose to come up on your client's leg? How far?
It went up mid-calf, according to her husband. At this point, I'm reserved. If there's any more questions.
My question is, you've stipulated, I thought, that this was an open and obvious condition.
We stipulated that the static hose was an open and obvious condition.
So had she
tripped
tripped
on the
on the way
static hose,
in, we're not here today.
we're not here today.
And that's when they, they filed their motion for summary judgment was based upon those allegations. Then you amend it to add this negligence of Mr. Alicia, and you're saying they should have then amended their motion for summary judgment to address the negligent conduct portion?
I believe that's what the rule 1.510 requires.
Even though you didn't add a separate count against the defendant? You just,
Correct.
so their theory was the same?
Yeah, their theory was that it was an open and obvious hazard.
Okay.
Thank you.
Good morning. Isaac Rudy Scruse on behalf of the appellee Westgate. I'd like to begin with that concession that the appellant has made, and that is that if this were a static hose, then summary judgment is appropriate. Because essentially their contention is that something about the hose moving takes this outside of the open and obvious danger doctrine and transforms this into a McCain foreseeable zone of risk case. I mean, that's what they've briefed. And there's frankly nothing in the law to support that type of abrogation of premises liability law. What is clear here is that this was an open and obvious danger. There were some, I think, misstatements with respect to what the factual record is with respect to that. It is undisputed that the pressure washer was running. The contention that somehow this was not running, Ms. Thompson in her deposition doesn't talk about the pressure washer running or not running. Her husband indicates that the compressor, I think, wasn't making any sound, but that it was clear that it was pressurized. He could hear the pressure washer, I think is what he said in his deposition. She indicated that when she came out of the building, so now on the way in, and there's 3 actual hoses. The testimony is there's 3 hoses running out of the compressor here, and those are what cross the sidewalk. And this area is coned off, and there is an alternate route to get in and out. But in spite of that, they decide to go forward with going over the hoses. And on the way in, they notice 3 employees at the end of the hoses. So there's folks out there working, obviously actively pressure washing. One of them says good morning to them. One of the employees says good morning to them. In her deposition testimony.
And there was testimony that, from the husband, that he turned to her before she stepped over the hose and said, watch the hose.
Correct. And she responds and says, I am. There's that testimony as well. She indicates on the way out, as far as this idea of are they using the pressure washer or not, on the way out that she notices that, and this is at page 71 of her deposition in the record, and he was using the sprayer, is that correct? He was washing down the bricks in the street. So before she's even crossing this hose, she sees that the employees are actually using the pressure washer and washing down the bricks on the street, and she still chooses to walk over the hoses. So this concept of this isn't an open and obvious danger simply because the hose suddenly moved when she chooses to walk over it. She knows that they're actively pressure washing at that time. So even if they tried to, and there's no record support for this, but if they tried to assert that she lacked knowledge that they were actively using the pressure washer when she entered the building, she certainly had that knowledge, and there is record support, that on her way out, she knew that they were engaged in the task of actually pressure washing. And yes, her husband testified that he noticed the 3 hoses on the ground, that they were actively pressure washing. And he said as he walked into the building, and this is on the way in now, not on the way out, when they all walked and safely cleared the 3 hoses, that he heard the pressure washer running on page 18 of his deposition, and that he saw 3 men at the end of the hoses pressure washing. So they were well aware that there was an activity of pressure washing going on. Now, the distinction that the appellant has tried to make is simply not supportable, and that is they try to parse the language of all the premises liability cases and suggest that because the word condition is used, that somehow that only refers to a static condition on the real property. And I tried to draw that distinction in our brief. The origin of
Tell me about is it Brookie case?
Brookie case.
That's the Winn-Dixie case?
It is.
Talk about that one a little bit.
Sure. So the distinction there, and the reason the appellant is suggesting that it's different, that was a pallet in front of the store.
That this plaintiff had walked past several times.
Several times, walks past it and on
Static condition, open and
static
obvious.
condition, third or fourth time trips and
The
falls.
third or fourth time, if an employee of Winn-Dixie accidentally kicks that pallet into the plaintiff's way, and he trips over it then, still open and obvious? Still static? Does it make a difference? It's a hypothetical I think the plaintiff raises that
Sure. I think that's obviously a unique hypothetical because you're talking about an
that dissimilar from this case?
I do think that hypothetical is quite dissimilar from this case because there's nothing about what the employee kicking the pallet is dissimilar to an employee engaged in a pressure washing activity. What was open and obvious to the person entering and exiting Winn-Dixie in the Brookie case is that there's a pallet there, not that an employee is somehow in an activity going to kick the pallet into that person. But in this case, it's open and obvious that there is a pressure washing activity going on. Obviously, part of pressure washing is hoses move. It's not a static activity. Anyone who's spent any time pressure washing would know that. And the plaintiff herself knows what pressure washing involves. They said they had the same compressor. I think the same color. It was slightly smaller, but they admitted they had the exact same compressor at home. So no, I think it's a different type of fact pattern that you're presenting in that hypothetical. What I was referring to with respect to the origin of the open and obvious doctrine, when Florida adopted it, it's really from the Restatement Second of Torts, Section 343. And what that restatement says is that a possessor of land is not liable to his invitee for physical harm caused to them by any activity or condition on the land when the danger is known and obvious to them. So the origin of the open and obvious doctrine as adopted by the District Courts of Appeal and the Florida Supreme Court in this state is from the Restatement Second of Torts, and it uses the word activity. It's not just limited to a static condition. So here I think the fact pattern that was presented is one in which summary judgment was appropriate. This is a pressure washing activity. The plaintiffs are well aware of what that activity entails. They know what's going on. They choose to cross over the hose. They assume that risk going into the building. Luckily, everyone clears it. On the way out, the plaintiff herself recognizes that pressure washing is actively going on. She says they're spraying down the bricks. She knows it. She's warned by her own husband to watch out for the hoses. And she says, I am, and she nevertheless trips on the hoses. The idea that somehow now you can plead around premises liability, and to be sure, all they pled was premises liability, and then they added a count after it appeared clear that summary judgment would be granted to try to get around it by creatively arguing that the McCain zone of danger applies and that you shouldn't use premises liability in the open and obvious doctrine. It plainly fails. We should not abrogate the premises liability law that exists. We should not abrogate the open and obvious doctrine in this context. It would exactly turn the law on its head and make business owners, landowners, the insurers for any type of individual that doesn't use their common sense. There were cones around this area, and they're doing it in the early morning hours as to not disturb guests, and these guests decide to plow through anyhow, even though this activity is going on. When that occurs, it is absolutely appropriate for the open and obvious doctrine to preclude them from being able to recover against the business owner, and summary judgment was appropriate. Unless there are any other questions? Thank you.
Thank you. You have a little less than 5 minutes.
The council made point to reference the restatement of torts that includes the word activity, but he failed to include any case in his brief that actually applied that word. Every case that he cited to involved a static condition, a parking bumper, a pallet, things where
Well, we have said some conditions are so open and obvious, and some even dangerous conditions that are open and obvious, that requires an invitee is expected to protect themselves from that. And clearly, in this case, we don't, I mean, she went over it, she knows it's dangerous, she steps over it, and so how can we say she didn't fail to
To
protect
apply-
herself from this open and obvious dangerous condition?
To apply a blanket ruling that's close to that would be to essentially say, if you create a dangerous activity or dangerous area that's open and obvious, and you see somebody's in that zone of danger, you don't have to do anything to protect them. You're completely free to continue doing what you're doing, whether it's throwing dynamite or
Well,
mining
this is,
or
let me
anything.
read you out of the Dampier case. It's out of this court. Some conditions are so obvious and not inherently dangerous that they can be said as a matter of law not to constitute a dangerous condition and will not give rise to liability due to the failure to maintain the premises in a reasonably safe condition. Other conditions are dangerous, but are so open and obvious that an invitee may be reasonably expected to discover them and protect himself. The rule applied in these circumstances is to absolve the landowner of liability unless the landowner should anticipate or foresee harm from the dangerous condition despite such knowledge or obviousness.
And there's our point. If we are going to fold this into premise liability, which we're arguing it's not, when you see somebody in the zone of danger, you should reasonably anticipate they're going to get hurt. And if you have something in your ability to prevent that from happening, like in this particular case, stop pressure washing until she clears the area, then that case would be in our favor, not against us. Because we're not arguing here that this was a situation where they were around the back of the building pressure washing and the hoses happened to be coming out and they could no way possibly see her. We're arguing that he was within several feet of her and looking at her. So they have a duty at that point, even under that case, to take reasonable precautions to protect her.
If the hose didn't move and your client slipped over water that was flowing, either sitting on the sidewalk or flowing as a result of a leak in the hose, you lose?
I think we'd have to determine whether it was, open and obvious water, but I think probably we
Well, it's
would
pressure
lose.
washing.
Yeah, we would probably lose that
you
one.
lose, right?
We would probably lose that one.
If the hose doesn't move.
Probably.
So it's just the fact that the hose moves, you win.
Yeah, well, if we took the water case, if the sidewalk was dry and then he decided to spray the water just as she was ready to step there, I think we'd win. But if it's just dripping out of the compressor and had been there for a significant amount of time, I think we would lose. But the point here is everything that happened because he continued doing what he was doing after he knew she was in the danger zone. So,
Well,
if
actually,
you-
it's not he didn't continue doing what he was doing. You're saying he intentionally moved or carelessly moved the hose
yeah, he violated his duty of care to her.
and watching her step over the hose.
While she was navigating the hose, he
While
was
she
indifferent
was-
to what she was doing.
While
Yeah.
she was simultaneously stepping over the hose, he carelessly moved the hose.
That's the testimony of her husband, yes. The Brookie case, I think, you were close to what our argument is, but I think we would take ours even further and say, what if it was an employee actually moving the pallet jack? That's the facts we're talking about, is he was actually in the course and scope of moving the pallet jack and ran into the Brookie person. We would consider that be closer to ours than just an accidental kicking of it. But I wouldn't allege that he was intentionally trying to run him over with the pallet jack. He was just indifferent to the fact that this person was there. That's our argument about Alicia. And I think we got to give Mrs. Thompson's words full credit. Her husband said, "Watch your step, watch the hose," and she said, "I am." That is her affirmation that she's trying to be careful of the hazard that she sees and perceives. If you believe that that wasn't enough care, then that's a jury question. It's not a matter of law that simply because she walks out the door and decides to go straight instead of left, she now is completely unprotected by the law.
And counsel, you're out of time. Thank you.
Thank you.
And we're in recess.